At UCT, I took an excellent course on principles of environmental law, where I began the paper that I'm presenting now. And I've further developed this paper since. And as Sandy mentioned, my title of the presentation is called Transnational. Can everyone see the presentation okay? Okay. My presentation is called Transnationalizing Public Trust Doctrines, Responses to Global Challenges of Biodiversity, Climate Change, and Oceans Management. And the presentation is not about South African law specifically, but more of a broad study on this common legal doctrine. So the introduction, so I'll just define a few key terms first. So the public trust doctrine has generally and traditionally been defined as that certain natural resources within national territories are common shared property among citizens and should therefore be stewarded and perpetuated by the state. And so the core concept here is that states steward natural resources for the benefit of the public. And so every public trust doctrine, or PTD, encompasses a different natural resource sets and different stewardship duties for states. And so my definition is really framed around stewardship. And so this stewardship has been broadly defined in environmental law scholarship. And one definition is that it's a general universal duty to care for the planet. And so this would relate to the overall purpose of PTDs. And then it's specifically has been defined as, the specific duties requiring landowners to carefully manage their land. So this would relate more to the tangible duties of PTDs. So my research question was, how are public trust doctrines transnationalizing in response to global environmental issues? So the presentation outline is I will first provide some background information. Secondly, I will discuss how PTDs have internationalized and become common environmental law regimes around the globe. And thirdly, I will discuss how they have transnationalized or are transnationalizing in response to transboundary and global environmental issues. And then lastly, I will provide some conclusions. And just a note, overall, my paper and this presentation seek to propose a new kind of conceptual framework for analyzing public trust doctrines against present-day issues. So for the background information, so the public trust doctrine can be traced back to the Roman law concept of res communis, where Justinian said, by the law of nature, these things are common to all mankind: the air, running water, the sea, and consequentially the shores of the sea. So the main objective of public trust doctrines has traditionally been public use and access doctrines. So it's about maintaining or managing these resources so the public can use them or access them. Whereas in the present day, this has really transitioned, especially since the environmental movement in the 60s and 70s. And now PTDs are more environmental protection doctrines. And so a question comes is, where do we find this doctrine? And the most common legal sources are case law, especially in common law systems, constitutional law, environmental law, indigenous law, international law, natural law, or combinations thereof. And so my research focused on two general types of PTDs. One would be formalized, and these are basically when the doctrine has been inscribed and expressly named in law. And this has been, of course, the most focused on within the literature. And I also looked at implicit public trust doctrines. So this is when these doctrines are implied through existing state stewardship duties or the broader concept of a public trust regime. An example would be in South Africa. So identifying South Africa's PTD it's been discussed that the prima facie origin would be in the section 24 of the Constitution, which has been discussed already today, that everyone has the right to the environment being protected for the benefit of present and future generations through reasonable legislative and other means. And scholars have outlined how this has been, later formalized through treaties and case law. And so the material scope of public trust doctrines, it's basically natural resources that are owned by a state or within the state territories. However, this is, in the present day, there's been a trend to expand the material scopes. So the most common public trust resources are ecologically fragile lands, forests, minerals, running water, seashores, but some legal systems now also include the atmosphere, and even all natural resources as public trust resources. And I reviewed I reviewed cases and literature, and these are the most common resources that have been identified. The geographic scopes have also expanded for many public trust doctrines. However, this has been much more controversial. And so traditionally, the doctrine only applies within national territories. However, there's a current trend to apply this beyond national territories in other state jurisdictions and also in areas beyond national jurisdictions. So one really explicit example is states have applied their doctrines to their territorial sea, the maritime zone of the territorial sea, which is 12 nautical miles from their coastline. However, some states have begun applying this to their exclusive economic zones, which is quite fascinating because they don't have complete sovereignty over that maritime zone. So it shows that the geographic scopes that's an example of them kind of starting to creep out and expand. And so what are the limitations of this? So like with most law, states, they're sovereign and can mainly apply and enforce law within their territories. And however, many scholars have expressed, and many activists and advocates have expressed a dissatisfaction with these limitations of the Westphalian sovereignty system in terms of environmental issues that are global or transboundary. So does transnationalization therefore threaten state sovereignty? And since PTDs have shown to be adaptable, from public access and use doctrines to being environmental doctrines, are they open to further adaptation to addressing more global issues? So these are some of the kind of background concepts I was exploring. So firstly, I'll discuss the internationalization of PTDs. And I looked at this because public trust doctrines are very widespread, and even legal scholars such as Peter Sand have recognized that public trusteeship has really been an underlying feature of treaties and international environmental law regimes all along. So not only within the national level, but also the international level. So I basically observed and defined 3 processes of internationalization, which you can see in this table. And I provided some examples, and the examples are non-exhaustive. So the first process would be the spreading to legal systems. So basically, this is that more states now have PTDs through internal developments and from the doctrine, moving across legal systems. And so this is basically identifiable in the number of legal sources and different legal systems that now include public trust doctrines or imply them. And so an example of internal developments for this could be through natural law or indigenous law or the drafting of legislation. And so then influences from other states in this respect. This has received the most attention in scholarship. However, most of the scholarship I've found frames this kind of movement of the doctrine as coming from patrimony of England or the United States, and it kind of assumes this one-size-fits-all public trust doctrine, especially within former European colonies or settled colonial nations like the US. So I basically started looking at kind of how we can complicate this and see what stewardship duties existed beforehand as well, because I think if we can better understand them within context, then we might be able to overcome some of their shortcomings. And Andrew Blackmore has more critically investigated South Africa's public trust doctrine in this way, and kind of its separation from this idea of, this English doctrine basically coming to South Africa. So he's done a very interesting project on this. The second process is through international law principles. So states have adopted and they're applying international environmental law principles that relate to the core concept of public trust doctrines. So some examples are the intergenerational equity principle, which relates more to the beneficiary component of public trust doctrines. So, for now we have to protect resources for the public. Then this, in a lot of case law, basically this principle has been applied next to the doctrines. And the prevention principle relates to the protection and caring duties for natural resources so that harm can be prevented. The neighbor principle relates to ensuring that natural resources are not harmed across borders and that they're used in a sustainable way on one side of the border. In the third process I looked at was states consenting to public trust regimes and expanding their PTDs through treaties. So one example returning to the law of the sea would be the Law of the Sea Convention, which has an obligation for all parties to protect and preserve the marine environment, and also more specifically the common heritage of mankind, of humankind. So this would be the international seabed has been, it's basically considered a global public trust resource in this way. So basically, in this way, PTDs have internationalized because this treaty has expanded what states' duties are. And so other examples could be the Declaration of the Rights of Indigenous Peoples, which, states have recognized the rights of Indigenous peoples to conserve and protect the environment. So this could be seen as a way as expanding public trust doctrines, or states transferring some of their duties to Indigenous peoples so they can have self-determination and stewarding, and with their stewardship systems, which also pre-exist. Newer, more, I guess, public trust doctrines that have been so-called imported. And so overall, there's a widespread existence of public trust doctrines, and this, in my opinion, warrants an analysis on if and how these doctrines can be applied against global environmental issues. So this brings me to the transnationalization component. I basically investigated how these doctrines are transnationalizing, and I again observed three processes and provided definitions and examples. And so the first would be states stewarding natural resources beyond their national territories, which would require the expansion of the material and geographic scopes. So like I said before, the international seabed has been considered the common heritage of humankind. So this requires states to steward a resource that's beyond their national territory. So that's one example of transnationalization. Another would be the marine biodiversity negotiations that are ongoing, and they're discussing biodiversity in areas beyond national jurisdiction as as also a global good. And also climate change litigation in different national jurisdictions is showing how states are beginning to treat the atmosphere also as a public trust resource. So the next process would be stewarding for the benefit of persons beyond citizens. And so this has basically included, like it says, states now recognizing that they should steward public trust resources for all of Earth's inhabitants, including, in some cases, future generations. This can also be seen in climate change litigation, which I'm sure many of you all have kept up with because it's quite prevalent in the news. And also with the Marine Biodiversity Agreement, recognizing the need to protect marine biodiversity for future generations. And lastly, the last process is jointly stewarding with other states. So this is transnationalization in the sense of multiple states working together to, for the common purpose of public trusteeship or working with a non-state actor. So for the Law of the Sea Convention, again, the International Seabed Authority has been delegated specific powers and duties to protect the common heritage of humankind. And there's also discussion, there's in the BBNJ negotiations, there's discussions of whether there should be a new institutional body to oversee marine genetic resources, for example. So this would be another example of that. And so, I know this was quite brief, and in my paper, I go through these examples and complicate them a bit more. So I'd just like to point out again that these are non-exhaustive examples, but they're evidence of the growing developments of transnationalizing this common doctrine. So in conclusion, public trust doctrines have internationalized, and there are common doctrines in regimes around the globe, and therefore they offer an opportunity to align diverse legal systems with a common legal regime against the same environmental issues. So there could be more research done on what existed beforehand before each of these public trust doctrines were realized within countries, and also on implicit public trust doctrines, and kind of just webbing together how different doctrines cover the same issue in the same way, or in different ways, but all contribute to it. And so for transnationalization, as I've discussed, the doctrine is adaptable, so it could be receptive to new information on these global environmental issues. And they are showing that transnationalization is advancing the national and international levels through the examples I provided. And there's growing use of public trust regimes for these global issues. And also more research could be done on the transnational procedural rights and remedies. So how, citizens of one country could potentially invoke their rights in another country that does not follow this doctrine. So in conclusion, I found that further adaptations and collectivizations around this ancient doctrine could encourage more upturns for Earth and our inhabitation of it. So thank you very much.